Georgia follows the Federal Consumer Credit Protection Act formula for wage garnishment and applies it straightforwardly, making Georgia a productive wage garnishment state for creditors. Here is the complete guide. The Georgia garnishment limit, the lesser of 25% of disposable earnings per pay period, or the amount by which disposable earnings exceed 30 times the federal minimum wage. Georgia does not impose a state cap more restrictive than the federal formula. Georgia's minimum wage. Georgia has a state minimum wage below the federal rate, but the federal minimum wage governs because federal law preempts state law where state law is less protective. The 30 times calculation uses the federal minimum wage for Georgia workers, disposable earnings in Georgia, gross wages minus legally required deductions, federal and Georgia state income taxes, Social Security, Medicare. Voluntary deductions do not reduce disposable earnings. Georgia garnishment procedure. Georgia requires service of the summons of garnishment on the employer, the garnishee, within a specified time after issuance. The employer must file an answer within 45 days. The employer withholds the applicable amount and pays it into court or directly to the creditor as directed. Georgia allows a continuing garnishment that attaches to future wages without reservice. Multiple garnishments. When multiple garnishments are in effect, Georgia processes them in order of service date, subject to domestic support priority. The total withheld cannot exceed the applicable statutory limit regardless of how many writs are outstanding. Exempt income, Social Security, unemployment, workers' compensation, disability, and military retirement benefits are generally exempt from garnishment in Georgia. People Locator skip tracing provides Georgia employer identification for wage garnishment, typically within 24 hours or less. Or visit peoplelocatorsskiptracing.com to place your order.